to the judiciary. Generous beyond my personal expectations. I will name a few of them. Hall of Justice of the Regional Trial Court and Metropolitan Trial Court in Marikina City. Merong isang malaking building doon na ibinigay ng local government unit ng Marikina upang gamitin bilang bahay ng mga Regional Trial Court at Metropolitan Trial Court, at yung may detention facility sa itaas, may prosecutor's office sa ibaba, etc. Malaki pong building ito. At nangako yung local government officials na kung kailangan pa, maaari silang magbigay pa ng another building. Welcome yan. Pangalawa, itong Hall of Justice para sa Metropolitan Trial Court sa Valenzuela City. Yung nakakaalam sa Valenzuela, alam ninyo ito dahil ito yung lumang munisipyo ng Valenzuela. Ni-refurbish ng local government unit at ito ngayon ay gagamitin ng Metropolitan Trial Court. Nauna dyan, bago ako naging Chief Justice, nagbigay na sila ng isang buong building na ginagamit ng Regional Trial Court sa Valenzuela. Magagandang loob yan. Pangatlo, yung sa General Santos City, meron isang buong building na itinatag ng local government unit ng General Santos City. 2-story building upang maging archives building ng mga court sa General Santos City. Walang gastos ang judiciary dyan, gastos lamang ng local government ng General Santos City. Doon sa probinsya ng Sarangani, yung courthouse doon, may dalawang malalaking courtrooms. Ngunit si Senator Pacquiao nag-initiate ng karugtong ng dalawang courtrooms na yan, at nagkaroon ng dalawa pa. Gastos lahat ng national government through Senator Pacquiao. Yung kanyang development fund. Na-inaugurate na rin yan. Maganda ang nangyari dyan. Number 5, and probably this has been so far the most generous, yung Quezon City. Nagtayo ng Hall of Justice ang Quezon City, 7 stories, walang ginastos ang judiciary dyan. At ang gagastusin lamang siguro ng judiciary ay yung mga laman, yung mga lamesa, mga equipment. Kami nagpapasalamat sa local government unit ng Quezon City led by former Mayor Bautista. Yung lupa naman ay marami ring nagbigay sa amin. Ang unang nagbigay dito at nais kong banggitin ay ang San Pablo City at ang Cebu City. Ang San Pablo City, kung kayo ay pamilyar doon, ang mga public offices, government offices, City Hall, regional trial courts, municipal trial courts, at saka iba pang mga government offices ay nasa loob ng isang compound na nung araw siguro ay napakalaki pero ngayon ay maliit na dahil sa marami nang nakatatag. Nakita ito ng namumuno sa San Pablo City, sila Mayor Amante at Vice Mayor at saka konsehales. At kami ay lumapit sa kanila at sila naman ay nagpaunlak. Kaya not too many months ago, pumunta kami doon upang tanggapin ang donation ng isang malaking lupa, 1.5 hectares, sa labas ng poblasyon ng San Pablo City. At ito ay gagawin naming probably a regional judicial center kasi napakalaki. Ngunit pinag-aaralan pa kung ano talaga yung mga itatatag dito. But we are sure that the regional trial courts and the municipal trial courts, as well as the support offices and allied agencies, will probably have their own house there. Doon sa Cebu City naman, tinanggap din namin ang pagpapalipat sa pangalan ng judiciary ng isang malaking property, very valuable property sa SRP. Yung mga tiga Cebu, alam niyo yung SRP, that is probably the most valued location for any investment that you make in Cebu City. 1.5 hectares. Ipinalit namin yung 7,000 square meter property doon din sa SRP na nanggaling din sa Cebu City nung araw. At itong bagong lugar na ito ay katabi ng UP sa SRP. Napakagandang loob ng Cebu City na binigyan kami nito. Ang pinakamalaki outside of Metro Manila na gagamitin ng hudikatura ay isang property doon sa New Clark City. Kung alam ninyo yung New Clark City, ito yung bagong development na ginagawa ng national government kung saan na ngayon nakalagay yung National Arena. Yung venue ng coming Southeast Asian Games na gagawin sa November. Yung binigay sa judiciary as its place ay 6 hectares na malapit sa SCTEX. At itatatag namin dito ang alternate Supreme Court venue, alternate to Manila. Some buildings will be housing Court of Appeals, Sandigan Bayan, and Court of Tax Appeals, and possibly a PhilJA regional office, as well as allied offices. Malaki yan. Galing ito sa Bases Conversion and Development Authority, led by President Vince Dizon. Ito yung nasa Kapas, Tarlac. Ngayon, yung pangatlong agenda ko ay enhancing the access to justice. Alam naman natin lahat na malaking pagkukulang natin sa mga underserved sectors of society. Hindi ko na tatawagin sila na underprivileged kasi napakarami nila. Mas gusto kong tukuyin sila bilang underserved kasi ito yung mga kababayan natin na hindi man lang nakausap ng abogado o hindi man lang nabibigyan ng sapat na lunas sa kanilang mga legal problems. Gusto ko na ma-expand yung access to justice upang maibsan yung kanilang pangangailangan. At kasama dito, upang malutas ito, yung law student practice rule na mag-expand ng legal representation to involve also the law students while they are still in law school, so that these underserved sectors will be properly, the needs of these underserved sectors will be properly addressed. Hinggil dito, gusto kong banggitin at magpasalamat sa Congress of the Philippines dahil nung nakaraang budget, tinagdagan yung 30 million allocation for legal aid ng IBP, Integrated Bar of the Philippines, ginawang 100 million pesos. Bakit? Ano ang pakialam ko dyan? Itong legal aid subsidy ng national government sa Integrated Bar of the Philippines ay dinidisburse ng Supreme Court yan. Kami ang trust, holders in trust of these funds. Hindi pwedeng ibigay ng outright sa Integrated Bar of the Philippines dahil kailangan malaman na may resulta na maganda. So, Supreme Court ang nag-audit niyan. At ito i-release ng Supreme Court ng dahan-dahan sa Integrated Bar of the Philippines kung kailan nila kailangan, and subject only to the condition na ma-liquidate in a proper manner yung paggamit ng pundo na ito. Malaking pagdadagdag karagdagan yung 70 million dahil this is a service that is rendered throughout the Philippines. We also have a need for good number of competent lawyers. Totoo na may kasabihan na masyadong marami na yata ang naging abogado, ngunit ang mga naging abogado, hindi naman lahat sila ay nagre-render ng service to the public. Maraming abogado na hindi na nila ginagamit ng kanilang profesyon. So this has resulted into a noticeable shortage of lawyers. Ang mga lawyers, they tend to be concentrated in populated areas kasi nandoon yung mga may kapasidad na magbayad sa kanilang mga services. Gusto ko na mas maraming abogado sana. Abogado na magagaling, abogado na tapat, abogado na marunong manilbihan. So, we are reforming the legal education system in the country with a view to improving and increasing or enhancing the law profession. So, kayong mga media, tulungan nyo kami rito upang akitin ng mas maraming magagaling na mga bata upang pumunta sa law profession. Kayo siguro, maraming kumukuha ng law, although occasional students kayo siguro. Kumuha na ng law. So, welcome. If you are already in law school, you can practice law on a limited scale based on Rule 138. You will be the owner of the case. You will not be there only as a dummy of somebody. You will be on your own, subject to the same ethical standards that are being imposed on lawyers. So make that known to everybody so that there will be greater pride on the part of the law student practicing before a judge. No, may self-confidence siya. Now, the last on my agenda is, of course, the inevitable one. Cleansing the ranks of the judiciary, of the personnel of the judiciary, as well as the ranks of the law profession. Lahat ito ay nasa ilalim ng pagmamasid at paggagabay ng Supreme Court. So, hindi maaring iwasan ito dahil napakahalaga ang pagiging strikto sa disiplina ng mga hukom, ng mga naninilbihan sa hudikatura at ang mga abogado na humaharap sa mga hukom. This is the only way, I think, that will ensure the observance of the rule of law in our country, which is so essential to our national life on a daily basis. Statistics from the Office of the Court Administration show that from January to June of this year, we fined 21 judges, we fined, suspended, reprimanded, or admonished 21 judges, and 94 lower court employees were dismissed from the service, admonished, fined, reprimanded, or had their benefits forfeited or suspended. We have also dismissed a lot of judges, suspended them preventively, which is very unusual because we found that these actions that we did were essential to maintaining confidence of the public in the judiciary. The same period, statistics from the Office of the Bar Confidant show that we have sanctioned 83 lawyers through disbarment, suspension from the practice of law, suspension from the notarial practice, or both notarial practice and the practice of law, fined, reprimanded, admonished, warned, and censured them. We also have embarked on several judicial reform projects even before I assumed as Chief Justice of the Philippines. Only last Friday, we were in Bacolod City to launch Bacolod City as the 5th Justice Zone in the Philippines. Itong Justice Zone ay isang city or lugar sa Pilipinas na ready na magkaroon ng Justice Zone. Ano naman ang importansya nitong Justice Zone? Itong Justice Zone, isang lugar na napili na magkakaroon ng close coordination among the judges, the agencies and officers serving under the Department of Justice, like the prosecutors and the parole officers and the PAO, and those offices and agencies under the local government department, like the police, the BJMP, and other agencies that work hand in hand with the courts and the prosecutors to deal with cases throughout the Philippines. Kung meron ka ng Justice Zone, itong tatlong agencies na ito, Judiciary, Department of Justice, and Department of Interior and Local Government, are closely coordinating with one another. Hindi na yung kanya-kanya. Unlike in other areas where there is no Justice Zone, kanya-kanya sila. So, madaling sisihan doon. Itong Justice Zone na ito, walang sisihan. Lahat ay responsable, parang isang unit lang sila. So, the principal, we have constituted these Justice Zones in order to find out if this is workable throughout the Philippines. Yung aking Bacolod City Justice Zone ay pangatlo sa aking pamumuno, because I am nearly the chairman of this Joint Sector Coordinating Council. I saw to it that I would have, at least before I bowed out of judicial service, 4 Justice Zones during my watch. Before that, in the 2014, there was the first Justice Zone, which was launched in Quezon City, and during the time of Chief Justice De Castro, another Justice Zone was launched in Cebu City. The experience in these 2 earlier Justice Zones warranted or called for the establishment of more Justice Zones. So pina-expedite ko yung pagtatatag ng mga Justice Zone. At least bago ako mag-retire sa Oktubre, may 4 na launch na Justice Zones sa akin. Ang pang-4 sa akin is Naga City, which will be launched in the end of this month. Thank you. Ito pa ang isang mahalagang improvement na nagawa o nangyari sa ilalim ng aking pagka-Chief Justice. Mahigit 15 years na meron kaming tinatawag na electronic library. Ngunit ngayon lang nagkaroon ng itong electronic library magbibigay ng access to a limited population, to a limited sector, like law students or law professors or judges, access to the resources of the Supreme Court like decisions, etc. Ngunit upon the suggestion of Attorney Hosaka, who is very savvy sa technology, sinabi niya na bakit hindi natin buksan itong mga materials na ito, resources na ito sa lahat, kahit na hindi involved sa delivery of justice. Ang ibig sabihin ng lahat ay kahit sino. Hindi na kailangan na mag-subscribe ka sa mga providers like Skra or Lex Libris. Mahal ang babayaran mo dyan eh. So, what did this improvement do? We have opened for the first time in 15 years itong electronic library or e-library ng Supreme Court. Walang bayad ito. Kung ma-access ninyo yung website ng Supreme Court, maintindihan ninyo ang ibig ko sabihin. Kung gusto ninyong malaman kung ano ang nangyari sa isang kaso, doon kayo pumunta at pwede kayong mag-access doon. Hindi na kayo kailangan na pumunta sa Padre Faura upang magtanong kay Attorney Hosaka. The e-library is a searchable database of jurisprudence that includes the SC decisions and resolutions from 1901 when the judiciary began up till the present. There are also laws that include the present and past constitutions, the issuances of the Supreme Court, like these present and past rules of court, as well as resolutions in administrative matters and other references accessible formerly only to judges and court personnel and lawyers. The court, through the PIO, also launched the newly improved and redesigned website of the Supreme Court and the Supreme Court application or SC app. Subukan ninyo yan. Makikita nyo yung mga pogi sa Supreme Court. Isa pa na ginawa kong kaagad nung ako umupo bilang Chief Justice, yung aking gustong-gustong may tatag noon pa nung ako'y nagsimula sa Judikatura noong 1986, parang ito ang dream ko na gawin. Magtatag ng isang judiciary memorabilia hall or museum. Ito'y nangyari noong inaugurate namin ito noong June 11, 2019, doon sa Old Supreme Court Building. Alam nyo ba na ang Supreme Court Building ay dati nandun sa Taft Avenue, corner Padre Faura. Noong umalis yung Department of Foreign Affairs sa Padre Faura, kinuha ng Supreme Court yung building nila. Ito ngayon ang aming present na inuokupahan bilang Supreme Court. Maraming bata sa inyo, hindi ninyo siguro alam ito dahil pag sinabi mo Padre Faura nung araw, ibig sabihin nun Department of Foreign Affairs. Pero ngayon, pag sinabi mong Padre Faura, PGH. Pero nandun pala kami. Ano? Padre Faura, Supreme Court. Dati kasi ang Supreme Court, Taft Avenue ang tawag nila. Yung katapat or katabi ng PGH. Pero we are now the main occupant of Padre Faura. Yung aming premises doon ay owned by the University of the Philippines kasi nandoon yung original campus ng UP. Inilipat yung campus ng UP sa Diliman, ngunit nandun pa rin yung mga ibang units ng UP still operating in that area. So the building that we are occupying now and functioning from, as well as that old building that we are using as the Supreme Court, yun ay nasa Padre Faura kasama sa campus ng University of the Philippines prior to Diliman transfer. Nandun sa old building yung Memorabilia Hall that we inaugurated last June 11, 2019. You are free to visit there anytime you want, provided if it is after office hours, you notify Attorney Hosaka or any of his subordinates so that you could be allowed to visit the place free of charge. Sabihan ninyo ang publiko na meron tayong ganyang memorabilia hall. Ano ang ma-expect mong makita doon? Walang kababalaghan. Ang makikita mo roon yung artifacts, photographs, and other articles that will acquaint you with the history of the Philippine judiciary. I have invited many stakeholders, retired as well as the incumbents, who have had anything to do with the judiciary to contribute any kind of memorabilia that may enlighten the public about how the Supreme Court has been, how the judiciary was, and how it will be in the future. Now, you are probably aware that the Supreme Court has already plans afoot to transfer doon sa BGC. Meron kami doon 2.1 hectares na area na tatayuan namin ng modern building para sa Supreme Court. We have already started the groundwork for this, ngunit nagkakaroon lang kami ng problema ng konti sa procurement as well as in right-of-way issues. Bayad na kami sa lupa na yan. Bayad na ang Supreme Court. Merong binigay na pera ang Congress sa amin at yun ang ibabayad namin binayad namin sa lupa. In the early weeks of my incumbency, I was the one who delivered the last check to pay for the value of that property from the BCDA. Hindi donation yan, bayad. So, but that property will not probably become useful until 5 years away. Wala na, hindi na kami miyembro ng Supreme Court. Marami kaming magre-retire na, ngunit we look forward to that because we always love the institution that we have been serving for at least 3 decades in my part. Now, lately, we also inaugurated yung modified or improved website ng Judicial and Bar Council. Subukan ninyong i-access yan at makikita ninyo ang pagbabago, or if you had not been to that site before, you would immediately realize that that site is very interactive and it will serve the purpose of giving you the information you might need regarding the people who are there in the JBC and the people who are applying in the JBC for judicial position. Another improvement during the time ni Attorney Hosaka and during my time, of course, yung court locator. Doon din sa website ninyo makikita yan. Kung gusto mo kung saan mo makikita yung isang courthouse sa Pilipinas, pumunta ka doon. Nandun yung address na ibibigay. Another one is what you call the SC app. Yung SC app, you try also to access that. Another improvement during our term is the lawyers list. Kung gusto mong malaman kung ang isang tao ay abogado, tignan mo yung lawyers list. Now, dati-dati ito, nandun na yon, law list ang tawag. Pero upon the suggestion of Attorney Hosaka, the Supreme Court under my watch, during my watch, authorized the renaming of that list from law list to lawyers list. Kung meron kang suspecha ng isang abogado ay maaring may kaso or maaring na-suspend or maaring na-disbar, doon ka magpunta at nandun lahat yung informasyon tungkol sa tao na yon. Ito'y ginagawa namin upang mabawasan ang kalukuhan sa legal profession. Maraming manlilinlang na nagpapanggap na sila ay abogado pa rin, ngunit matagal na pala silang pinigilan ng Supreme Court. Ito'y bilang pasasalamat at pamamaalam sa inyo. I was telling many of you who arrived early that this should have happened many times before. I really wanted to meet with you. I looked forward to this kapihan. Ngunit kanya-kanya tayong problema sa oras. So ngayon lang tayo nagkita-kita na naman. Ewan ko kung nagpunta kayo nung ako'y nanumpa bilang Chief Justice at hindi ko na kayo namukhaan, maalala pa kung nandun kayo. Ngunit nagagalak ako at makita ko kayo ngayong umaga at ako naman ay, kung ito ay celebration sa inyo, pamamaalam din sa akin ito. Dahil sa next month, middle of next month, ako ay magre-retiro na bilang maestrado, bilang punong hukom, at hindi ko alam kung manunumbalik ako sa private sector o meron pang use sa akin sa public sector. So with that, I am very appreciative of what you have done today to be coming here to share, to break bread with me. And you will always be in my consciousness hereafter. Walang masama sa atin. Hindi ako nang huhusga ng kapwa. Mahal ko kayo lahat. Huwag nyo lang akong hinga ng pera. So, with those words, I open the floor now for your interview or questions. And thank you again.
Okay, the floor. Bubuksan na natin yung open forum, no. When we started this, ganito yung setup na ginawa natin na tugma kay Chief, no, very open, na madaling lapitan, no. So, before you ask your questions, kindly use the microphone in front of you and introduce yourself, please. Thank you. Any questions? Good. Go ahead.
Sir Benji from the Philippine News Agency. I would just like to ask, ano na sir ang prospects nung Manila having its own Hall of Justice?
Alam niyo, yan ang pinaka matagal ng plinaplano at nagkaroon ng ilang groundbreaking na yan. Sa aking tingin, may budget na yan, na-approve na namin yung design at procurement process pa rin yan, hindi ko nga maintindihan. Alam niyo kung bakit na-delay yan ng matagal. Noong kami ay mag-uumpisa na sana na bakbakin yung old GSIS building. I don't know if you know that building used to be the location of the GSIS offices. Mayroong isang organization, historical daw, etc., who openly challenged the establishment of the demolition or modification of that building kasi historical daw. Walang problema yon. Kung nandun sa batas na proteksyonan mo yung mga ganon, okay lang. But it delayed somehow the commencement of the construction. In-approve na namin yung design. Napakaganda ang design. And the projected design is going to allow for 120 courtrooms or rooms to be established there. We will preserve the facade because that is what the intervening group wanted. But we will build a high-rise structure that would house modern, at least modern or updated courthouses doon sa likod ng konti to the side. Ang last update sa akin ay malapit nang matapos yung mga problems. Pero may budget na yan eh. Dati-dati, there was a plan to build the courthouse on that site ng likod ng Hayalay. Nagkaroon din ng groundbreaking dyan. Ang Manila Courthouse was to have been the first of all courthouses or halls of justice in the Philippines to be constructed. Panahon pa ni President Cory yan. Ngunit mayroong isang judge na nag-issue ng injunction. Kasama siya, pero siya nag-issue ng injunction and no one could persuade him to lift the injunction. Hindi naman pwedeng diktahan yan dahil judicial matter yan, ano? So, ganyan katanda na yung problema na yan. Manila, na-delay na ng na-delay. Naunahan na ng Quezon City, naunahan na ng Iloilo, Cebu, etc. So, we are in earnest in trying to construct finally a fitting Hall of Justice for Manila, the former Queen City of the Philippines. Former. Kasi marami ng reyna na mas magaganda. Teka, I will connect this to another matter, no? Bago umalis si Mayor Erap as Mayor of Manila, nagpadala ang Manila ng demand letter sa Supreme Court upang umalis na yung mga husgado sa City Hall. Kasi kung nakapunta kayo sa City Hall ng Manila, napakalaking building yan, pero 1930s yata itinatag yan. Ewan ko, si Ray lang yata nakakaalam yan eh. Napakasikip ang corridors na ngayon sa City Hall ng Manila. At dapat lamang siguro nasabihan kami ng City of Manila na umalis na. Alisin na namin yung mga courtrooms doon. Ngunit hindi naman ganyang ka-urgent yung pagkagawa ng demand letter. Sinabi lang na you vacate kung meron na sigurong lilipatan. Manila kasi, kagaya na sinabi ko ngayon lamang, ay dapat yan ang nanguna sa lahat ng mga halls of justice. Ngunit ito na ang pinakamatagal na matayuan ng Hall of Justice dahil maraming, hindi ko naman pwedeng sabihin na pilosopo, ngunit hindi naman ayaw ko rin sabihin na balakid sila sa progreso. Maraming issue lang na dumating. Ang daming gustong magpundo sa Manila, World Bank nag-offer, pero hindi namin tinanggap yon. Gusto namin na kongreso natin ang mag-finance tungkol dyan sa construction na yan. So, yan ang status ng Manila. Nag-iintay pa rin.
Sir, follow-up lang din. My name is Evelyn with the Philippine Star. Sir, tanong lang, if you've already talked to Mayor Isko Moreno with regards lang po sa construction ng Justice Hall po sa Manila po.
Yes, pero hindi problema ni Mayor Isko yan. Problema namin sa Supreme Court yan. Inaayos lang namin ng gusto procurement stage na yan. Dapat yan naumpisahan na kasi overdue na talaga. Yung pera naghihintay. Kung kailangan ng panibagong appropriation, siguro naman magbibigay ang Kongreso dahil naunawaan din nila ang role ng Manila sa istorya ng ating bansa. Sa nakikita ko lang, nadidelay lang yan dahil may mga minor problems. Hindi na yan magtatagal, umpisaan na yan. Bakante pa yung, yung GSIS building. Are you old enough to know, to remember? Yung GSIS, di ba, Aroseros, okay. Doon kasi sa GSIS, may malaking lugar doon sa likod ng old building na, ewan ko kung anong ginagamit yun, parang parking or parking, doon namin tatayo yung mataas na building for the courthouses. Kasi, pangangailangan ng Manila talagang is malaki. Kasi napakalaki ang population niyan. Pero inabutan na siya ng Quezon City at saka ibang lugar na marami pa rin mas malaki na yata kaysa sa Manila. But you can never discount Manila because historically that is the sentimental capital of the Philippines. Doon tayo, Manila, Manila. Kantahin nyo nga.
Chief, good morning po. Sir, is the Supreme Court, Chief, I'm Lian Buan po from Rappler. Chief, is the Supreme Court thinking of or doing more reforms to have a more proactive role in addressing rising killings in the war on drugs? Because I believe a few years back, merong Human Rights Committee na supposedly being headed by Sandigan Bayan Presiding Justice Cabotaje Tang. Ano po yung update sa committee?
Itong war on drugs, meron talagang tumututok dyan, ano? Ngunit, alam mo yung war on drugs, hindi ko pwedeng sabihin na yung lalahatin. Because each case will have its own specific facts and background. You know, we are always very clear about the police agencies and the enforcement agencies being held to task whenever they violate. Ang problema kasi sa war on drugs, there are two versions always, no? One, the side of the government, and the other, the side of the victim or whoever gets killed in the action. These cases usually end up in cases in court, so we cannot make a total approach dito. Of course, siguro meron ng mga NGOs who are looking into this. We have a few cases that are filed in the courts for amparo, etc. No? So, more or less, hindi ko masabi kung ano ang extent ng pagmomonitor sa war on drugs. We will leave it to the investigative agencies to determine this. If you will look at the history of this campaign, every now and then lumalabas yung sila General Albayalde na dinidenounce nila yung mga bata nila who have abused their powers or their police authority supposedly. Kahapon mayroong ini-interview na nahulihan na pulis na nagsasabu tapos so yung tungkol dyan sa violent part of the war on drugs, niimbestigahan pa ng Senate, naimbestigahan niya ng Senate. So hindi kami masyadong in dyan because we have to respect also the jurisdiction of our trial court judges who are looking into each individual case. But as far as the court is concerned, we are alert to this need to look into the root causes of this campaign yan. That's part of the executive's turf. No? Mahirap na makialam dyan because we respect the independence of the executive department.
Mr. Chief Justice, good morning. Mike, sir, from ABS-CBN News. So I'd like to ask, it's a bit of an academic question, but the Supreme Court from time to time has been accused of judicial legislation in some of the decisions. For instance, in setting, for example, elements which were not, supposedly according to critics, were not included in the law itself. If I may cite some examples, Mr. Chief Justice, for example, in the acquittal of former President Arroyo, the Supreme Court was accused of citing the concept of a master plunderer. And in the case involving Danding Cuangco's share in 20% in San Miguel, there were two elements. For example, the need to prove that these ill-gotten wealth came from cronies or close associates of the president, of former President Marcos. To what extent, sir, do you think that these criticisms are valid, and how do you draw the line between judicial legislation and actually judicial interpretation? Because in the recent issue of, for instance, the GCTA, there were also issues surrounding some people blaming the Supreme Court for the decision coming out. So how do you address that issue, sir?
Yung accusation of judicial legislation ay most often unfair. Okay. Let me go to your first target, yung plunder. I was the one who wrote that decision, so I'll give you an academic answer because your question is academic. Anyway, that is already a final decision, so hindi na ako masyadong constricted dyan. And good that it is me who is going to answer such a question. If you read the decision, this was the peculiarity of that case. There were 10 accused there, one of whom was the former president. All of them were government officials. Now, if you look at the definition of plunder under the law, the elements of plunder are mainly the act of amassing, accumulating, or there is another one, wealth, okay, or money at least 50 million in amount committed by a public official. Nakalagay doon, of course, the singular includes the plural. So, if there were 10, sabi ko doon, if the allegation in the information does not say which of the 10 was the main plunderer, is it fair to blame them for the whole amount of 350 million? Because amount was a very essential element of plunder. At least 50 million nakalagay doon. If you did not identify in the information who of them, of the 10, was the main plunderer, will you be able to try all of them for plunder And if you did try all of them for plunder, not conspiracy, will you be justified in convicting them for plunder kung ang 350 million divided by 10 will only give you a product of a dividend of 35 million? Okay, that was only one of the issues. Now, is that judicial legislation? No. Although the law did not use the term main plunderer, it was needed to point out na you, the prosecutor, must state in the information which of these public officials that you are accusing is the main plunderer, so that all the others merely contributed. Now, what was my reason for that? I based that on the information that charged former President Estrada. The information there was very, very clear na it was Estrada who was the one who amassed. There were three kinds of actions there. And he was a public official, and the information specified that he was the one who amassed. Now, doon sa mga nagbigay sa kanya ng pera, they were spokes in a wheel, and he was the hub. Nakalagay doon eh. He was the hub. The information was very clear about Estrada being the one who amassed, who accumulated, or collected all this money, more than 50 million. Pero doon sa information charging GMA and the others, walang nakalagay kung sino sa kanila. And yet all of them were government officials. So unless you make that clarification, which is only one of several reasons for acquitting, you will not understand what plunder really is in that particular context. So that is not judicial legislation. It's an interpretation to make the law operate. And the courts are free to do that, because unless the courts are allowed to do that, they cannot enforce a particular law. Ano pa yung isa?
Sir, dandingkuhan ko, sir. Kaya nga,
Hindi, meron pa isa tungkol sa plunder na yan.
Which one?
Hindi, yung kuhang ko yung Cronis. Alright.
Yes,
Yung kay kuhang ko naman ganito. It was also I who wrote that decision. Siguro nag-research ka, no? And that was many years ago na. Ay, abogado ka, Mike. Okay. Itong 20% of San Miguel's tax, ganito yan eh. The question there was, these were supposed to be public funds, sabi daw ng isang decision ng Supreme Court. The Sandigan Bayan said, no, these were not public funds. These were the shares of Danding Kuwangko because he purchased them with his own money. Okay. The issue that was this was the money used to buy the 3% of which we did not or could not do because this is going to be more or less a crime. So we cannot veer away from the textual presentation of the term or the concept. Now, what would you consider as judicial legislation? I remember a very specific example. Under Republic Act 6425, yung former, the predecessor of our present drug law, itong batas na ngayon, okay, nakalagay doon, that the penalty when the quantity is this and that for selling dangerous drugs is this. Kalagay doon, prison correctional to reclusion perpetua. Alright. Interpretation ni Justice Regalado nung araw, there are 4 days na nakalagay doon. Ano yung correctional, mayor, reclusion. In order to make that law operate. Kasi ayaw naman palitan ng Congress. Nagkamali sila. There are many other situations or occasions when the Supreme Court must use its activism in order to read something that is not apparent in the language of the law. But yung judicial legislation na sinatawag nila is, I think it is generally unfair to say that the Supreme Court indulges in judicial legislation. At any rate, we can assure the public that whenever that happens, we have self-criticism. Nagbabakbakan kami sa loob before it ever wins the argument, yung matter na we interpreted something out of the express language of the law. I hope that hindi masyadong mataas yung pagkabaliwanag. Because I'd like the people to understand that we are not involved in judicial legislation. Lawyer ka talaga.
Chief, I heard about judicial activism. Now, yung current issue po ngayon is GCTA. Di ba? Yung tanong kasi ni Attorney Mike over there is medyo for academic discussion. Kasi ba nagtanong siya, tinamaan siya kanina dun sa lawyers nyo na you are urging lawyers to practice their profession, etc. etc. Medyo ngumiwi po siya ng kaunti kanina dun nakita ko yun. Kaya medyo masyadong malalim yung tanong niya. Judicial legislation. Ang tanong ko po naman, activism. Chief, final na po naman enforceable to, yung GCTA. But will the Supreme Court, ito po common tao na tanong, will the Supreme Court accept any petition from an affected party? Number 1, di po, naging justiciable ang issue kasi concern. Affected siya, may judicial standing siya. Tatanggap po, say, from the party of a victim, of a detainee who is expected or is about to be released, and then thereafter open up the case anew. Because you said before, yung issue on the interpretation ng whether heinous crime, etc., hindi na-tackle ng original decision because the only issue tackled there was, is it prospective or retroactive? Sir, tatanggap po immediately ang Supreme Court any petition from any aggrieved party. Thank you.
Maganda yung tanong mo na yan at very timely, Ngunit ang sagot ko ay simple lamang. Kung ang isang petition ay kumpleto ang compliance with technical requirements or procedural requirements, iproproseso ng Supreme Court yan. As to what issues will be raised there, it will depend on whether that issue is premature or not yet justiciable. Assuming na justiciable na yan, we can surely accept. Although, we will wait for such an eventuality. Tungkol sa good conduct time allowance, mahirap kong pangunahan kung ano ang mangyayari dyan or ano ang ipafile dahil ang aming tinakal lang doon sa decision namin yung sinabi mo na whether the guidelines should be applied prospectively only as the guidelines stated or retroactively as we decided. I think these matters that are being discussed in the public investigations of the Senate will deal probably with a specific situation where an applicant or where a person who is presently detained will probably be denied release. No? So that is a good time na to say na justiciable na siguro yan. But hindi ako mangunguna. Kasi it all depends on the crafting of the petition, whether the Supreme Court can exercise its jurisdiction over the particular matter. So I will leave it at that. Bakit hindi kung may justiciable?
Sir, good morning po. Christine Patag from Philstar.com. Sir, balik lang po ng konti sa war on drugs. I remember in December last year, after Representative Batocabe was killed, there was a call for independent probe between the judiciary and then the law enforcement agencies for the killings and the threats that lawyers are facing. Sir, may update po ba doon? Or is the SC or the judiciary making a move pa regarding din sa sinasabi ng lawyers that they're being threatened right now under the war on drugs po?
Will you say it again? Are they being threatened?
Yes, sir. They're saying that they're being threatened po. There's a rise in the killings dahil po sa war on drugs. And then the lawyers that are taking drug cases po, they say that they're facing threats. And then last year, there was a call for independent probe po. So may update.
Who are under threat?
The lawyers, sir. The lawyers taking on drug cases po.
I don't know kung totoo yan, ano? Ngunit I'm not ready to make a conclusion that there is such a threat. Lawyers know how to defend themselves. Lawyers know how to denounce any kind of threat. I think the Integrated Bar of the Philippines has been very proactive and aggressive in espousing this. Yung mga pinapatay na lawyers, they always come to the fore, to the front, and make issue demands for greater protection to lawyers, etc. Pero hindi ko pwedeng pangunahan ng bawat isang kaso tungkol sa nangyari or investigasyon na ginagawa pa lamang. Until I have the facts, I cannot give an opinion. But as the head of the judiciary, and because of that, I am also the father of the practicing bar or Integrated Bar of the Philippines. I have always been ready to go to the defense of any lawyer who is unjustly or prejudicially treated by the law enforcement agencies. In fact, just Attorney Hosaka here is privy to our conversations. We have always given authority to him to go to the public defense of those who are being intimidated or treated unfairly by law enforcers, etc. So I will just let it go at that. Thank you.
Sir, you mentioned dun sa nagkakabakbakan when among the justices when discussing. Sir, out of curiosity lang, how heated would you describe the deliberations had been in the Falsis case?
Walang hit dun. Anyway, this is part of the case. Nung there was an oral argument, no? If you had been sitting in during that oral argument, you probably have heard some of the justices very strongly come at the the petitioner, including myself siguro. But you know, I restrain myself from engaging in such. But it could not be avoided that he would be asked if he had applied for the marriage license and was denied because he is a self-proclaimed gay. And if he had done that and his application would have been denied, it would have given more justiciability to his case. But then we found out that he did not even bother to apply for that license. So, kung ang kanyang dinimanda ay civil registrar, parang walang laman yung kaso. Pero inilabas na namin kahapon yung resolution namin dyan. And the voting was that we should dismiss the case because it is not justiciable. Wala siyang standing eh. Kung may kakaroon ka ng standing dyan if you suffer injury and you needed the court to, yes, there is no actual controversy ang tawag dyan. May controversy lang naman dyan kung natamaan ka. Hindi siya natamaan.
Sir, one follow-up, if I may, sir. Did the fact that the law he was challenging was more than 30 years old, did that play an influence on members of the court?
No matter how old is the law, there is still an opportunity for the court to examine the constitutionality based on the current constitution. Marami kaming ginanon na batas eh. There was one case that I decided, sinabi ko pa nga, overtaken by the present constitution because the present constitution had so many provisions on local government units that were not in the earlier constitutions. So when that law that we considered was passed by President Marcos, yung presidential decree, it did not yet take into account what the present constitution said about local autonomy and preference given to local government units. So on that basis, we declared that law unconstitutional in terms or in the context of this existing current constitution. So wala kaming limit eh, basta tungkol sa labag sa batas o labag sa konstitusyon, i-declare namin kahit na kasintanda ni Adan yung batas.
Hi, Chief. Sir, Anjali Marco from CNN. Sir, balikan ko lang yung ruling sa Falsis case. Sir, just to clarify, this case isn't the road for same-sex couples because you didn't touch on the substantive part of the case.
Yes, right now that case did not resolve anything about same-sex marriage, etc. The opinions that were expressed there, which were several, will not be controlling. Wala kaming matawag na president doon because all of these opinions that they submit are merely what you say dictum proprium or sarili nilang opinion. So what we voted on or what we decided was to dismiss these cases because there is no case. Hindi naman. Yung technicality na salita ay sometimes hindi welcome sa amin yan because it seems to disparage the value of a certain resolution. But when we dismiss something out of technicality, we are simply saying that you should come to us with a proper in the proper vehicle. Many times na nangyayari yan. So try to understand that the Supreme Court is not technicality based. It's only enforcing its own rules regarding the minimum. Remember that in the Constitution, we are required only to handle actual cases and controversies. We cannot give advisory opinions. So when a case is not worthy of a case or controversy, there is no case or controversy, we avoid saying anything more except to dismiss. Now, we cannot prevent any of our members from expressing their personal opinions, but those will be personal opinions. Now, supposing a future litigation will cite those personal opinions, it will be up to the court at that time, when the case is considered for deliberation, to follow what that personal opinion said. Ganun naman eh. That is the progression of jurisprudence. Yung kung minsan nga, yung walang value ngayon will become the value tomorrow. So that often happens. But right now, doon sa case ni Falsis, dismissal lang ang nasunod doon.
Sir, some of the recent majority decisions have been strongly criticized by your fellow justices. For example, in first martial law, sabi ni Justice Leonen, emboldened the rise of an authoritarianism. Yung last martial law, sabi ni Justice Hardaleza, an abdication of the court's duty. And yung Boracay, sabi ni Justice Kagiwa, the realization of a tyrant. Those kinds of dissents had impacted the perception of the court as an independent branch. How would you defend po the Supreme Court and the majority concurring votes?
I do not need to defend the majority at in any given case. No, you know, when you are in the dissent, you have more freedom. You have more freedom to say your piece, what you want. In fact, if you were to ask me now personally, I would enjoy being in the dissent. I would enjoy writing my own dissent rather than the majority opinion. Because when you write the opinion of the court, for the court, you are constrained by the consensus. Yun ang dynamics doon eh. Now, whatever a dissenter will say, that is for his personal or her personal consumption. Kung yan ang gusto niyang language, wag lang bastos. We allow it. We allow it. We do not censure. They have the fullest freedom of what they will write there kasi hindi naman binding sa majority yan eh. Now, if they criticize the majority, they are free to do it, but they should do it within bounds. Wala kaming restriction sa kanila. In fact, I dissented in a few cases, and I will even say I criticized the majority opinion. Kung hindi mo gagawin yon, walang kwenta yung dissent mo. And you know, now that you ask me, that is what gives us the dynamism. We are open to criticism within the court itself, and we need people like Leonen, Kakiwa, and Hardaleza telling us that we are shit. Don't use that word. We welcome it. Basta wag lang, there are limits eh. There are limits. I will not say that the debate in the court is involved, vitriolic, etc. No, that is confidential. We are guarding that very well. If you wanted to know if that is true or not, you go to your access. And sabihin mo, off the record. Pero otherwise, I appreciate the dissents that have been filed in all these controversial cases because they convey to the public that this is not a sunod-sunuran court or this is not a leaderless court. We have leaders, kasi ganito this has often been mentioned by many of my colleagues. In the court, we are so independent-minded. 15 kami. The one that is sitting next to you during the argument, in one case, may be your ally. In the next, kayong nagdedebate. That is how the setup is. It's like this. A table like this, although smaller, magkakatabi, pero hindi naman nagsisikuan, but they do not agree on certain issues. And the vote is taken. Ganyan lang. Like kahapon daming divided decisions. But after the decision naman, the beauty of our setup there is, after that, we repaired to the next room, which was the dining room, and we eat there, banter about what we decided, or we do not even talk most often about what we have just done. That's how conviviality is in the court. Alam mo, during my time, no, maraming nagsasabi sa akin, how were you able to preserve the camaraderie in the court? I did not have to preserve that because all those in the court are very responsible people. They are very mature, and you don't need to talk to them, to cajole them, or to walang primus inter pares lang ako. It's enough that I bring across the message that I value each of them. Walang favoritism, walang gano'n, ha? Human nature yan. So, it's the reason why I always mention, hindi kailangan masyado yung mataas na IQ. Ang kailangan mo, EQ lang.
Thank you. We have time for just one more question. Meron ba? Give chance to there.
Sir, I'm Jerome Anning from the Inquirer. Sir, I want to ask about this other duty of the Supreme Court as the Presidential Electoral Tribunal. Can you give us an update dun sa pet case involving Vice President Robredo? Or baka kahit wag na, basta can we just want to know parang when will it end? Parang halfway na ng term ni Presidente. So, yung uncertainty or certainty according to both sides.
This is something that I have to share with you,
When it will end.
The Supreme Court is the Presidential Electoral Tribunal. But the Presidential Electoral Tribunal has a separate identity. But this is a matter of very high public interest because it involves also, to an extent, the stability of the government, the Philippines. It is so foremost in the minds of all the members of the PET to do away with this case, to resolve this case in the earliest possible time. But we have to understand also the needs of this case. We have to be very careful about what to decide here. We are aware that the public is uneasy about our foot dragging, siguro ang tawag nila dyan, but it is not really foot dragging. If you would know the effort that we have expended in the revision process, ito kasi, this is a combination of a protest as well as a variation of protest. Kung protest kasi, you need to count votes. Now, under the rules of the PET, there are, on the part of the protestant, precincts or provinces that have been identified which should be subject of the vote count, of the examination of ballots. And that took time, so we brought in revisors, etc. We appointed 3 commissioners so that we will be spared the task of going over these ballot boxes, clustered. Very soon, we are expecting that the ponente, who is Justice Giwa, will come up with his report. And he has informed us that this report will be a very voluminous report. And that is expected because when you have revisited or revised ballots coming from at least 3 provinces that were part of the protest, you would expect details of whether this ballot, that ballot, etc., are to be part of the counting or not to be part of the counting. Okay, I know the impatience of the public about this case of the Vice President being protested, but we should also be careful about what we do here because the credibility of our processes as well as of the political system here is at stake. So, dahan-dahan kami, but we are doing it with sufficient speed. Slow in the public's perception, but yung speed namin, kung tutuusin mo, ay mabilis. Now, even if there is a perception na nadidelay yan, we are also doing our share from within. we are reminding each other, no, hindi lang yung ponente, we are reminding each other about the need for results. We do not say that this result should come tomorrow or the next month, etc. It all depends on how we process the protest. Now, there is another kind of protest which involves whether there was massive fraud or not. This does not depend on counting of individual ballots. This will depend on probably a finding that at least a sufficient number of votes were fraudulent or were influenced by terrorism, etc. So that is the next thing that we will probably do. But I'm not going to mention here kung ano na ang progress dyan because I am not yet authorized to divulge any result in that respect. There was one part of it, there were 3 causes of action and one of them was already dismissed upon the motion of the leader, Bongbong Marcos. So let's all pray. I think I join you there that we should be concerned really, but we are doing everything according to processes.
Chief, thank you. So, there's a request just to give a short message of before we close the salo-salo or the kapihan. No? A short, very short message regarding your legacy to the judiciary and to the Supreme Court.
Before I went into that, I remember that Ray here said something about judicial activism. All right, since you are my friends in the media, let me just give you my idea of what judicial activism and judicial ano ba yung isa? Restraint what they mean to us in the Supreme Court. Many sectors misconceive or misunderstand or misapply these two concepts. We often talk about them but we do not fully understand. Or maybe my understanding of it is different from your comprehension of these terms. What I understand judicial activism to be is that here is the Supreme Court going to intervene in policy. No? And you do not call that activism unless it is an intervention. On the other hand, here is what you call judicial restraint. The Supreme Court is, as a general rule, a judicially restrained institution because we respect the separation of powers. We respect the functions of the Congress within its own sphere. We respect the executive's privilege within his own sphere. And they also show us that same respect. Kagaya ng statement ni Secretary Guevara, napakaganda. Ay, paggalang niya sa Supreme Court tungkol sa bagay na may kaso, decision ng Supreme Court, yan ang gusto kong expression of what judicial restraint really is. Restraint on their part, restraint also on our part. Sinabi niya, we respect the decision of the Supreme Court doon sa retrospectivity of the good conduct time allowance. Yes, he said that publicly in the Bacolod launching of Justice Zone. There were others. Even the President respects or restrains himself from saying anything about the Supreme Court. Congress also. No? So, siguro controversial lang kami. Pagka kami, we are content to stay in the bylines. Akala ninyo hindi kami concerned na we are reluctant to involve ourselves. No. This is how you should view the Supreme Court. The Supreme Court remains to be a passive institution. Passive when it comes to things that happen outside of the Supreme Court. Passive because we do not interfere or meddle in public affairs unless there is a petition that comes to us in the proper manner. We cannot just make a statement about some things that happen without an actual case being involved in those activities. On the other hand, I was explaining this also when I was initially interviewed upon my assumption. When are you judicially when are you a judicial activist and when are you not? This was my simple answer. There are cases where I should be judicially an activist. And what are these cases? When it comes to an accused who is unjustly charged with a crime, when it comes to the environment, when it comes to public health, when it comes to public safety, I always exercise judicial activism. Meaning, I go out very aggressively. On the other hand, when am I judicially restrained? When it comes to a challenge against a law that was passed by Congress, by two houses of Congress, deliberated there, and then you take part, the executive takes part by signing that into law. You cannot just simply brush that aside. You must respect the independence of these two branches and that they collaborated together. You should give credit to that. Now, doon sa martial law cases, for my part, I speak only for myself. Here is a declaration made by the President, immediately under our Constitution, reviewed by the two houses of Congress in joint session assembled. They both branches of government decided that martial law was justified or the extension of martial law was justified. Ito, I am talking about the past cases, not talking about the new cases that may be coming. Okay, so when I was deliberating on that last extension, sinabi ni one of our members na inconsistent yung mga reports sa pinagbatayan ng President. And I was asked that publicly nung nasa Sandigan Bayan ako. When I visited the Sandigan Bayan, there was an ambush interview. Ambush ba yun? So, my immediate answer was this. You know, when the President receives information, and the information comes from a source that he usually relies on, he may not have the time to check whether that information is correct, valid, or fully supported by the events. And if he relies on that, you cannot in hindsight tell that he was wrong because he already acted on it. So, no matter the inconsistencies that may have been in hindsight discovered during the hearings sa Supreme Court, I'm not saying na mali yung mga no. The judgment should be made by the President at that moment that he received the information. And so he declared that the martial law in Mindanao should be extended. And then the Congress in joint session, nagkaroon sila ng public discussion there, hearing, etc., closed door and executive session, and sinabi ng mga intelligence officers na really gagawin natin extension. And the Congress believed them. So these are two branches of government, independent of each other, by constitutional mandate. Nagkaroon sila ng performance or discharge of their duties. Then you challenge that sa amin. No? Now, our task there was to determine whether hindi grave abuse. Although we are still not clear about whether it is grave abuse that we should be using there or not. The standard of review is, was there a good faith reliance by the President on the information and then acted on it? So, yun ang persuasion ko when I voted in favor of the extension, that the President was given information that convinced him to extend martial law, and Congress was given information that they relied upon to approve the declaration of an extension. Okay, I'm now going to my final statement. Thank you very much again for this opportunity to be with you. Really, I have my reasons for meeting you today, because it is not every time that I have an opportunity to sit with you and to be with you, as well as to share and break bread with you. I would have wanted to do this more frequently, because you are very valuable partners of the Supreme Court in educating the people, telling them about public affairs and how our institutions work. I've been very happy to have had the pleasure of your friendship, of your support. I know that you might have expectations that I did not fulfill. All that I ask of you now is to share whatever you wanted me to do in the remaining days of my service in the judiciary by connecting with the PIO through Attorney Hosaka so that I can be apprised of your concerns and I could quickly address those concerns. It has been my policy to approach this job with an open mind. You know, my upbringing from my infancy up to the moment, I have not been brought up to hate. I've been very open-armed towards even I forswore all conflicts because I would not be effective if I were judgmental of others. So ganyan ang treatment natin sa isa't isa sana. I do not care if you come from an organization that is perceived to be establishment or anti-establishment. That is not possible with me. I am open-minded, I am open-hearted, and I love you all. So thank you for this opportunity to be with you.
Okay, can we request the